Hi, welcome to today's video. We'll be catching up with Patrick Smith from O'Brien and Smith Solicitors, which is just across the road from us, just to get his opinion on and expertise on things to consider when going through separation. So over to you, Patrick, and welcome.
Thanks, Rachel.
Taking the time out. So today I just want to talk a bit about separation. Not another great topic, but something that's becoming more common, unfortunately. So just a bit of perspective on, I guess, a bit of a guide for clients or people where to start when they are going through that process.
Sure. Yeah, it is a difficult time for anyone, and I think probably the first thing that we should consider is how we best deal with it so there's not more problems down the track. So actually going in and seeing a solicitor as soon as you possibly can is important to make sure that you do the right things from day one, because if we don't, we can have big problems, become more expensive and worse for you down the track.
Yeah.
One of the things that we can do as well is just take a bit of a review of all of our financial situation and detail what that is. So actually look at what assets you have, what liabilities you have, what assets and liabilities your partner have. And you can actually collect the documents that support that, so bank statements, superannuation statements, race notices, those kind of things. Then when you have your first appointment with your solicitor, straight away your solicitor will know where your situation lies,
Yeah.
and you'll get a better picture of what needs to happen going forward as well.
Yeah, perfect. That sounds fair. So you've covered off what information they should bring as well. What documents, I guess, should they consider that may need altering as part of the process?
Well, one of the most important ones I think is probably your will. If, like most people, are leaving a lot of their estate to their partner, once you're in that relationship, you probably don't want that ex-partner to receive a large share of your estate. So really important to get your will reviewed straight away. Similarly, superannuation now is such a big part of someone's assets because balances just continue to grow. So you want to review what your binding death nomination is. Again, you might have said previously that everything was going to go to your spouse. Now it'll be a good idea now to actually review that and think of where you want that to go to. Now, a bit of a tip here, you might think, I want it to go to my children. If the children are over 18, that might not be the best option. So good to speak to your solicitor about that as well.
Yeah, sure. In regards to that, when you're nominating children as beneficiaries that are minors, what implications can that have? If something was to happen in regards to, I suppose, ex-partners and things like that, do they get a bit of control back in that circumstance?
Yeah, so it's something that you want to be careful with, because we can't actually leave assets under your will to a minor child, so that's a child under 18. It will need to be held on trust for that child. Now, in a situation where you don't trust your ex-partner or you don't think that the assets would actually be going to your child, that might be that you want to say, I appoint a trusted friend, for example, or a sibling to be trustee for that child, so that your ex doesn't have any control over those assets for your children on your death.
Yeah, okay, good. Another one, I guess, which is important and an emotional one for parents is how do they arrange care for their children and get to an agreement, or hopefully.
Yeah. It's a really difficult time for people going through a separation, and I guess the biggest thing is to make the focus on the kids and making sure that they don't take part in any of the dispute between the two of you. Yeah. So it'd be really good if you can actually have a chat with your ex-partner and say, how about you have them Tuesday, Wednesday, Thursday, I have them Friday, Saturday, Sunday, Monday, whatever arrangement it is, but actually come to an agreement between the two of you, and you can actually talk to the kids about it together. Now, sometimes that's not going to be possible when you've got a partner where you really hate each other at that point in time. But if you can, that can be good for the kids as well, just to make it as less stressful for them as you possibly can. In terms of recording that agreement, what we usually use is just what's called a parenting plan, and that will just set out what that agreement is between you, so in terms of who has them at what times. And that can be really helpful because everyone knows where they stand there. There can't be an argument, I was meant to have them or you were meant to have them. We can both just go back to the agreement and say, this is what we agreed upon. That was what was meant to happen.
And I guess what happens if someone doesn't uphold their end of the bargain with that parenting plan, where does that stand, I guess, from a legal point of view?
First steps, go to your solicitor and you try and actually just resolve it between the parties to say, well, hang on, you're not complying with this agreement. And then if they don't, they continue to disregard the agreement, then it might be that we have to go to court. And if we go to court, then we might seek court orders, which actually say you have to have the child from these days to those days. The other person has it from those. So that's more, I guess it's more certain, it's legal binding compared to the parenting plan. But hopefully that won't be necessary. Hopefully the parties can just agree between them that a parenting plan is sufficient.
That's right, and you'll also save on costs too.
Exactly
I
right.
can imagine it's, yeah. Patrick, how are finances between ex-partners finalised? There's sort of a few options there.
There are. So I guess the worst option is when there is an informal agreement between the parties or no real agreement and they just go off and do their separate things. The big risk for that is that down the track, say there's changes in circumstances, someone gets into a really good financial position, the other partner could then actually go to court and say, well, I need a share of their assets. So really we want to make sure that the parties' financial positions are finalised. The second option is actually to do what's called a binding financial agreement.
Okay.
So that's where the agreement's recorded in a pretty lengthy legal document. Both partners are required to get independent legal advice. They can't go to the same solicitor about the positives and negatives of that agreement. This is better, clearly, than just going off and doing your own thing, but it's not as final as court orders, because you don't have a court saying, I've reviewed these, I believe them to be fair and equitable, so I'm making them. So court orders are the best option. And the best way to go about it really is if we can get an agreement between the parties of what they want, and then go to the court with what's called consent orders, and they say, well, this is what both parties agree is reasonable. Person A gets this, person B gets that, and there'll be a formal court order which says that's the case. If there can't be an agreement, which sometimes happens, the partners have different views on what they're entitled to.
Yeah.
Again, you can go to court, and again, it's a costly exercise. So if you can avoid going to court,
at all costs, yeah.
always better to do so. Yeah.
Yeah, absolutely. I think that sums things up for today. Thanks for your time, and yeah.
Thank you, Rachel. Thanks.